Sir, today I want to clearly understand this topic, Registration Act 1908. Honestly, many times we treat it like just documentation, but I feel there is something deeper connected with valuation also. Am I right?
Yes, absolutely right. See, Registration Act is not only about paperwork. It is about giving legal identity and public recognition to property transactions. Without registration, transaction is like informal understanding. With registration, it becomes legally enforceable and publicly recorded.
So basically, registration converts a private deal into a legally accepted transaction?
Correct. And more importantly, it creates transparency in the market, reduces fraud, and builds trust. For valuers, this is very critical because we depend on legal authenticity of title.
Sir, now I want clarity. When exactly registration becomes compulsory?
Good question. Any document which creates or transfers rights in immovable property and value exceeds 100 rupees must be registered.
100 sounds very old benchmark.
Yes, practically all transactions today fall under this. Now understand important categories. Sale, gift, mortgage, exchange. All these directly affect ownership rights, so registration is mandatory.
And leases? I remember some condition is there.
Yes, lease is compulsory to register when it is from year to year, or exceeding 1 year, or reserving yearly rent. Short-term lease may not require registration.
So duration and structure matters in lease.
Exactly. One more important point. Court decrees.
Court orders also?
If court order results in transfer of property rights, then yes, registration is required. Because final impact is change in ownership and that must reflect in public record.
Now suppose someone does not register. What happens practically?
Consequences are serious. First, document cannot be admitted as evidence in court.
So even if transaction is real, it cannot be legally proved properly?
Yes. Second, no legal interest is created.
Meaning ownership is not legally transferred?
Correct. Third, transferee does not get legal rights.
So buyer becomes legally weak position?
Exactly. From valuation point of view, such property becomes high risk and sometimes non-marketable.
Sir, what is the exact role of registrar office in this entire system?
Registrar and sub-registrar are government-appointed authorities. Their role is not just clerical. They ensure documents are properly registered, records are maintained in public register, legal procedures are followed.
What kind of checks they do?
They verify proper stamp duty payment, identity of parties, proper execution of document.
So they act like a validation authority before document becomes official?
Yes, exactly. They ensure only legally valid documents enter public record.
Now coming to valuation perspective, how exactly this affects our work?
This is very important. First, registration gives public notice.
Meaning everyone is considered aware of that transaction?
Yes. Second, valuer must verify chain of title.
Which includes ownership history and continuity?
Correct. Also encumbrances. All this comes from registered records.
If one document is missing or unregistered?
Then title becomes defective or doubtful.
And that directly affects value?
Very much. Non-registration leads to weak legal standing, poor marketability, reduced valuation. Banks may also reject such property for lending.
So final understanding, registration is not just compliance, it is directly linked with value?
Yes, you can say legal clarity leads to trust and trust leads to value.
Understood. This makes the entire topic very practical.
Always remember, as a valuer, you are not just valuing land and building. You are valuing legal rights attached to it.